Sanbonani, Dumelang. I hope Nyapila, guys. I hope Nyapila. I hope you guys are surviving. Hope you guys are surviving. You guys are well. Hope life has been treating you well, guys. Thank you very much, guys. I just want to appreciate you guys for the continued support of viewing the channel, viewing the videos, and subscribing. And thank you very much to those who have already subscribed. To those who have not yet subscribed, please guys do that. And the benefit of subscribing is that each time I publish a video, you get notified. And I think those who have been following the channel have noticed that there's a pattern now. I normally publish videos on Wednesdays and Saturdays. So please subscribe to make sure that you don't miss out on these videos, guys. All right. Guys, we're still on the CCMA rules that were released on the 21st of April 2023. So we've already dealt with chapter 1, part 1, part 2, and part 3. Today we're going to be dealing with part 4 of the rules. Okay, let's jump right into it, guys. Part 4, arbitration. How to refer a request for arbitration to the commission. Number 1, a party may request the commission to arbitrate a dispute by delivering a duly completed LRA Form 7.13, which may include using the official commission electronic referral online portals. Number 2, when referring a request by means other than the official commission electronic referral online portals as set out in Schedule 1, requesting party must A. attach to the request written proof in accordance with Rule 6 that the request was served on the other parties to the dispute. B. It is required to attach to the request an application for condonation if the request for condonation is referred after the relevant time limit has expired. Very important, guys. Despite Rule 18B subsection despite Rule 18 subsection 2B, where a request has been referred out of time and if condonation has not been attached to the request, the commission will decide whether the condonation will be determined at a hearing or by written submissions received from the parties. Number 4, this rule does not apply to con-eb proceedings held in terms of section 1915A, read together for Rule 17. Remember, the con-eb is the one we dealt with in the previous video. Number 19, when must the parties file statements? 1. The commission or commissioner may direct A. the requesting party in arbitration to deliver a statement of case, and B. the other parties to deliver answering statement or affidavit. 2. A statement in terms of Sub-Rule 1 must A. set out the material facts upon which the party relies and legal issues that arise from the material facts, and B. be delivered within the time period specified by the commission or commissioner. Number 3, the commissioner has a discretion to continue the matter despite non-compliance with the directive of the commission or commissioner in terms of Sub-Rule 1. However, any non-compliance may be taken into account when considering costs at the conclusion of the arbitration hearing. Number 20, when parties must hold a pre-arbitration conference. Number 1, the parties to arbitration must hold a pre-arbitration conference dealing with the matters referred to in Sub-Rule 3 if A. both parties are represented by a trade union, employers organization, legal practitioner, and or a candidate attorney. B. both parties agree to hold a pre-arbitration conference, or C. directed to do so by the provincial or regional senior commissioner or the senior commissioner in charge of a region or the presiding commissioner. 3. In the pre-arbitration, Number 2, a pre-arbitration conference convened in terms of Sub-Rule 1A and B must be convened at least 14 days prior to the date of the scheduled arbitration. 3. In a pre-arbitration conference, the parties must attempt to reach consensus on the following: A. any means by which the dispute may be settled. B. facts that are agreed between the parties. C. facts that are in dispute. D. the issues that the commission is required to decide. E. the precise relief claimed, and if compensation is claimed, the amount of the compensation and how it is calculated. F, the sharing and experience of relevant documents. F, let's just go back to F. The sharing and exchange of relevant documents and the preparation of a bundle of documents in chronological order with the page numbered. G, the manner in which the documentary evidence is to be dealt with, including any agreement or the status of the documents and whether documents or parts of the documents will serve as evidence of what they appear to be. F, okay, H, whether evidence on affidavit will be admitted with or without the right of any party to cross-examine the person who made the affidavit. I, which party must begin? J, the necessity for any on-the-spot inspection. K, securing the presence at the commission of any witnesses. I, the resolution of any preliminary points that are intended to be taken. M, the exchange of witness statements. N, expect evidence. O, any other means by which the proceedings may be shortened. P, an estimate of the time required for the hearing. Q, the right of representation, and R, whether an interpreter is required and if so, for how long and for which languages. Number 4, unless a dispute is settled, the parties must draw up and sign a minute setting out the facts on which the parties agree or disagree. Number 5, a minute in terms of sub-rule 4 may also deal with any other matter listed in sub-rule 3. Number 6, the referring party must ensure that a copy of their pre-arbitration conference minute is delivered to the appointed commissioner 7 days prior to the date scheduled for the arbitration. Number 7, the commissioner may, after receiving a pre-arbitration minute, A, direct the parties to hold a further pre-arbitration conference and or B, issue any other directive to the parties concerning the conduct of the arbitration, including rescheduling the matter for hearing on another date. Number 8, the commissioner has a discretion to continue for the matter despite non-compliance with the directive in terms of sub-rule 1 or the provisions of sub-rule 4, 5, and or 6. However, any non-compliance may be taken into account when considering costs at the conclusion of the arbitration hearing. Number 21, when must the commission notify parties of an arbitration? The commission must notify the parties in writing of an arbitration hearing at least 21 days prior to the scheduled date, unless the parties agree to a shorter period or reasonable circumstances require a shorter period. If a notification is sent by registered mail only, an additional 7 days must be allowed. 22. How to determine whether a commissioner may arbitrate a dispute. If during the arbitration proceedings it appears that a jurisdictional issue has not been determined, the commissioner must require the referring party to prove that the commission has jurisdiction to arbitrate the dispute. Number 23, how to postpone an arbitration. 1. Subject to sub-rule 2 and 6, an arbitration may be postponed. A, if the commission is satisfied that there is written confirmation to postpone by both parties. B, by application to the commission and on notice to the other parties in terms of sub-rule 3. Number 2, the commission may postpone an arbitration without the parties appearing if A, all the parties to the dispute confirm in writing that they agree to the postponement, and B, the written confirmation for the postponement is received by the commission at least 7 days prior to the scheduled date of arbitration. Number 3, if the conditions of sub-rule 2 are not met, any party may apply in terms of Rule 31 to postpone an arbitration by delivering an application to the other parties to the dispute and filing a copy with the commission before the scheduled date of the arbitration. Number 4, after considering the written application or confirmation, the commissioner may A, without convening a hearing, determine whether or not to postpone the matter, or B, convene a hearing to determine whether to postpone the matter, or C, determine the application in any manner the commission deems fit. Number 5, there is no right to postponement, and arbitration will proceed as scheduled unless the commission or commissioner notifies the parties that the matter has been postponed. All right, guys, thank you very much. That's the end of part 4 of the new CCMA rules, the new rules that were released on the 21st of April 2023. In the next video, then we'll deal with part 5. So now we'll end there with part 4. And thank you very much, guys, for viewing this video. Thank you very much for viewing the channel. Thank you very much for subscribing. Those who have not yet subscribed, please do subscribe. Those who are using Twitter, please share the video on Twitter. Those who are using Facebook, please share on Facebook. Whatever social media platforms that you are using, please let's share this video on those platforms. Let's encourage others to view, to subscribe as well. Thank you very much, guys. Lisedi.